All right. So my understanding is that you were outside speaking with members of the jury. Is that correct? That's either yes or no. No, no, no. You were outside speaking to the jurors. Yes or no? Nope. Were you outside speaking to the jurors? Yes or no?
Yeah, detaining. It's a difference between getting arrested.
This is what's going to end up. All right. And what division? All right. Do you have documentation for that? Oh, what is your name? Spell that. First name? And last name? Yes. Spell it. And where's your documentation that show you work for the federal government? All right. So you are not allowed to be in this courthouse anymore. You do not have any business here. If you are not a witness, you are not allowed in this courtroom. Do you understand? And you're not allowed in this courthouse. You know that you are not supposed to be speaking with the jurors in the hallway. You were. Those jurors were not asking you any questions. You took it upon yourself to tamper with the jury that is coming up here for jury selection. You are not allowed in this courthouse anymore. Do you understand? No. Do you understand? So do not come back into the courthouse. That means this courthouse. That means the courthouse next door that is the historical courthouse. Do you understand? All right. All right. If you can see that he's escorted off the premises. So I will speak to all of the defense attorneys when you all come back. But personally, I don't feel comfortable with using this jury as the jury pool because I don't know what was said. My understanding is that he is involved in a case here, not as a witness, not as a party whatsoever, but just as maybe a friend of a friend of a friend of a cousin.
Will you hand me my spin box? Now go free.
All right. I'll see you all for jury trial tomorrow at 9:30.
You had said if we had any pre-trial motions to bring those up.
Yes.
All right, Judge. So I had filed a motion back in August of 2023, a motion to prohibit the YouTube broadcast of all the legal proceedings.
We're going on the record in 2022 CR 5802, State of Texas versus Philip Diller. We're going to have parties announced for the record for the state.
Anna Ochoa Nelson.
Defense.
Alex Scharf for Mr. Diller.
All right, defense, your first motion.
Yes, Judge. The first motion is the motion to prohibit the YouTube broadcast of all legal proceedings in Mr. Diller's case. The basis for that is that he's got a constitutional right to a fair trial. And by broadcasting what happens during the trial sets up great room for error to happen. As you're aware, the court previously had a trial where one of the witnesses, the complainant, admitted to watching the YouTube testimony of at least another witness.
And you do realize that that complainant testified first, correct?
Yes, Judge.
Okay.
But just for example, that was a main witness and she admitted to watching YouTube. I'm concerned about witnesses watching YouTube. I'm concerned with potential jurors watching YouTube or asking friends or family to watch it for them. And so I'm just really concerned that Mr. Diller won't get a fair trial with this being broadcast all over the internet.
All right.
Now,
And would
I
you
would-
want the media excused as well?
Usually the media doesn't video record.
Yes, they do.
Out of, when the jury's out of the courtroom. Like, for instance, like if there's a motion in limine and we're arguing about prior criminal record or something, the court grants it.
Mhm.
I don't think the news cares about that. But if a juror were to see that, or a witness or one of the witness's friends, then they could let that slip out
Mhm.
when the court has already ruled on that issue.
So you're okay with the media coming in filming, is that correct?
I don't have an objection to that.
Okay.
I don't have an objection to that. It's just broadcasting everything that happens in the case.
All right.
The reasons that, and I will, in the motion on page 2,
Mhm.
paragraph 5, I want to waive that paragraph because I do believe the court has changed the YouTube channel and does not allow chatting any further.
Mhm.
And so I will waive that. I'm also concerned that there's an alleged victim who is a minor. And under the Texas Constitution, Article 1, Section 30A1, that person has a right to privacy, and that by broadcasting it, her name will be revealed.
Mhm.
And also, whenever the jury is picked, their names are called out loud, and that's supposed to be done secretly.
Mhm. All right. Is there anything else with regards to your motion, counsel?
Well, the main focus is the concern for Mr. Dillard getting a fair trial based on only the evidence that is presented in court and not broadcast or archived videos of earlier proceedings that are watched by potential jurors and potential witnesses.
Okay.
And that's just too huge a risk.
All right. And this is your only pretrial motion?
No.
All right. So that motion is denied. What's your next motion?
I haven't filed it yet. It's ready to be filed. I can hand file it. Before I file it, I would respectfully ask the court to recuse
Okay.
on this case.
Sure. We'll have a hearing on that,
Okay.
and that will be heard by Judge Hall. Ms. Ferguson, if you could call Judge Hall to see if he can have that heard immediately. All right.
Okay. And then the motion was a motion to recuse
Okay.
on that.
Oh,
So
that's fine. Oh, counsel, you can file whatever motion you want to file.
Okay.
All right, and see if he can have that heard and let him know that this is scheduled for jury trial tomorrow. So perhaps if he can hear it in the morning, and that way we can move directly into jury trial. Is there any other motion?
not for today, Judge. Like, we'll probably have a motion in limine whenever.
All right, you may want that heard because technically you have not filed the motion to recuse yet.
Right. You are right.
So,
You are right. Well, I can file it electronically when I get back to the office, or I can hand file it.
well, either you need to file it now. If you don't file it now, then we will hear other motions.
Our original 3 copies.
All right, and Ms. Ferguson, see if Judge Harl is available to hear that today, and we will be coming back here on the 17th for trial.
Oh, wait, today or tomorrow morning?
Let's see if we can hear it today or either early tomorrow morning.
Okay.
All right. Thank you.
Thank you, Jen.
You're welcome. Raymond Alejandro, why was your client late?
Back to impact court on the second floor.
Why would he go to impact court?
We had previously been to impact court.
Had a message from, on a text message to tell me to be down there, so that's why I went down there, but I saw that they were in trial, so came up like a breeze.
All right. All right, the jury will be brought up at 11.
Okay, Judge, we have one motion that we wanted to,
Oh, I've seen it. I denied it.
okay,
All right.
could we at least put it on the record?
Oh, sure. Court is calling 2022 CR 1331, State of Texas versus Raymond Alejandro. Could I have parties announced for the record for the state?
Ally Jackson for the state.
Defense?
Matthew Allen for the defense.
All right. Your motion?
Judge, we have a motion, the court has, recorded Mr. Alejandro's previous proceedings and trials. They're recorded on YouTube. That the jurors, the potential jurors in this case, that'll be brought up can see. We'd like those for them to be removed. I'm not sure what benefit it is that that previously recorded proceedings are up on YouTube. But the danger to Mr. Alejandro is that it doesn't give him a fair trial because we can't be certain that the jurors are gonna only review the material that's given to them today, along with the witnesses. And so, again, we don't see any reason why they would be up on YouTube or recorded to leave up there. And so we'd ask for those to be removed.
All right. And here's my question. Have we had any hearings with Mr. Alejandro that have required witnesses?
Yes, he had a
And what
trial.
was that? Okay, so he had a jury trial,
Yes.
correct? All right. So this is what you need to be aware of. Your colleague requested and had a judge sign an order that no videos were taken down. So that probably may need to be taken up with your colleague who did that. And when I say colleague, I mean in general.
Oh, okay.
Yes. So a court has signed an order that I'm not to remove any. So therefore, this motion is denied.
But, Your Honor, I guess that I'm not sure what, I may or may not know, but I'm not positive what court. But I guess we'd like at least an opportunity to go in front of that court to explain the dangers. It's a little bit of a different case that his case was tried and a mistrial, and now we have a retrial. So we have a whole trial up on
Yeah.
broadcasting. So,
Okay. All right. And so that'll be something that you'll need to question the jurors about, and I'll make sure that the jurors have not viewed that.
and Judge, by doing that, all I do is bring the attention that the proceedings have been on YouTube. So we run into that danger again. So
Okay.
I don't know if.
Well, yes, the court has that order. So,
I understand. I guess. Yeah. I would like to be able to try to go to that court then to explain.
well, it was a hearing that was under seal and a motion that was under seal, but for someone, I don't know who, decided to speak about sealed hearing. So what I can tell you is an order was signed by a judge, and therefore all videos remain.
Judge, I guess then I would ask for a continuance to look into that, or at least
Mhm.
let that play out so that Mr. Alejandro can have.
All right, that-
what we believe would be-
Your motion for no recording. Do you have any objection to the media being present in the courtroom to record the trial?
We would not want anyone to record this.
So you want the media excused as well?
They could be in, but any recordings we would ask.
All right. All right, your motion to withdraw video and your motion to not have recording, that's denied.
And then just for scheduling purposes, I have a federal sentencing tomorrow afternoon. I believe Mr. Calvis has a federal sentencing. He should be up here, but I just wanted to make the court aware.
Okay, all right. We'll of course work around that schedule.
Okay, and would we pick today and start testimony tomorrow?
Yes.
Okay.
All right, thank you.
23 CR 99 is called the State of Texas versus Michael McCray Duncan. You are Mr. Duncan. Is present with your attorney, Mr. Galmore, and the state's attorney. Does the defendant wait for formal reading of the indictment and arraignment here? Can we proceed in start?
He does.
In summary, this indictment alleges that on or about September 30th, 2022 in Jefferson County, Texas, you operated a motor vehicle on a public place while intoxicated. Paragraph 2 goes on to allege that you have 2 or more DWI convictions. Paragraphs 1 and 2 constitute a third-degree felony if found guilty. Do you understand?
Yes.
A third-degree felony carries with it, if convicted, a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached between the parties. You would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on probation for 10 years. And there will be, and also as a condition of probation, you must spend 10 days, right?
We made an agreement for 15.
Hold on. Under the law.
That's correct, Your Honor.
You must spend at least 10 days
Yes, Your Honor.
in the county jail as a condition of
Yes.
it could be up to 180 days, but the law says at least 10 days in the county jail. And there's a non-binding recommendation that you would be ordered to perform 15 days in the county jail on weekends, which would, you only get 2 days credited. So that would be 7.5 weeks. 8 weeks. You would have to serve that last week only 1 day, if my math serves me.
That's correct.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand? How do you plead to paragraphs 1 and 2 in this indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
And paragraph 2 of the indictment, which alleges these prior convictions of on February 8th, 2013 in County Court of Chambers County, Texas, you were convicted of a DWI. And also on November 20th, 2013 in County Court of Law 2 of Jefferson County, you were convicted of another DWI. Are those allegations in paragraph 2 in this indictment true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily? And because it is those allegations are true.
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney? Or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All true, it states, so help you God. Is that so?
Yes, sir.
And Your Honor, just with regard to restitution, there's potentially a small amount that's still owed. I know there was a settlement between them individuals who they were the back of their vehicles ran into that they I know they settled most of, if not all, of the claims, but there could be still a small amount out there. So potentially, once I speak with the party to determine if there's any, I'll let probation know the amount.
So restitution is ordered in some amount that the parties agree will be determined by the post-sentence report in the probation office. Is that right?
Yes, sir.
Okay, that's correct.
Yes, sir.
All right. Because by law, restitution has to be ordered at the time of sentencing. That's a very important issue in a very important case that was taken up on the Court of Appeals out of this court, which we had followed. But it was one of those which had to be determined. And it said that was, as long as restitution is ordered in an amount to be determined, then there's a period of time, a reasonable period of time where it can be determined, and then that order of restitution would be carried out as part of the judgment. If nothing further, I'm going to find you are pleading guilty and true to paragraphs 1 and 2 respectively of this indictment voluntarily, knowingly, intelligently. There's sufficient evidence supporting your plea of true and guilty from State's Exhibit 1 admitted here to support all of your pleas to find you guilty beyond a reasonable doubt, as I find that you are pleading guilty voluntarily, knowingly, intelligently, and because that is what you wish to do. I accept your plea, find you guilty beyond a reasonable doubt of this third-degree felony of operating a motor vehicle in a public place while intoxicated, according to paragraphs 1 and 2 of this indictment. I am following this agreement. You were hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 10 years. That term of 10 years confinement shall be suspended. You were placed on regular probation for 10 years. There is no fine. However, restitution shall be ordered in an amount that is what is agreed upon by the parties, that is not covered and already fulfilled by insurance reimbursement. Do we know about what it is?
I know last time when I spoke with
What was the total
I think it was around $1,300, but I just
What was the total amount that the insurance was?
I'm not sure. I know there was an indemnity agreement. They settled out all the claims of it. I know that's what the victim in this case told me, that I believe there's roughly $1,300, but I don't. That was still waiting to be settled out.
Roughly $1,300. What?
In restitution, of medical bills, I believe.
That's still unreimbursed.
That's correct, but again, I need to update that and see if that was settled or not, because they were settling with his insurance
But
company.
there was an amount that
A small amount, yes, you're
That
right.
was- that is reimbursable somehow in one way or the other to the victim in this case, or the complainant.
Yes.
Correct?
Yes.
Everybody agrees. Right. And then you're nodding your head, Dustin. Well, this court is ordering restitution in an amount to be determined by the post sentence reports. If there's an issue on that, let me know. We'll just deal with it. There will be other terms and conditions of probation, such as a DWI repeat offender program, 366 in Honolulu. I used to jog there when I was a little kid. I lived right off the Honolulu. And 366 was a major intersection. There was a chemical company that was right there at that corner, right across from, it's Huntsman now. That was Jefferson Chemical, but across the street from there, would have been the south side of 366 was a small company that was boarded up and fenced off and had all kinds of security around it that the United States government had. They made Agent Orange.
Interesting.
Yep.
Yeah.
Anyway, that's what I know about that intersection, but it's a major intersection. What was the alcohol content on this event? No.
3.316.
Good Lord. You need, hello, unless you've gotten a grip on it, you need some help. 0.30,
316.
316. Well, that's 4 times the legal limit. Do you see anything wrong with that? What are you doing? Because operating a motor vehicle while intoxicated is a very selfish thing, because everybody is at risk. I'm going to roll everybody's eyes, but this is a 4,000-pound missile you're operating, and you're high as a kite. Too often people come in here who have been either seriously injured or killed, and there's nothing more sad than those people wondering how that happened to them or their child or their relative when they were following the rules and someone was operating a 4,000-pound missile recklessly and out of their mind. It's a very selfish thing to do. We have to share the road with everybody. But you have to appreciate the next person's life, that you care. If you don't care about yours, which would be foolish, you need to care about all the people who are trusting other drivers to be responsible. But we see it over and over again, and it's catastrophic. I mean, it's gruesome. And that's the case where we have more people weeping in this room, wondering how that could happen. I mean, you got to get a grip on this. This is your third time, but when you were in an accident here, a collision here, well, you're lucky. You know, people go to prison if someone is injured or killed generally in a DWI. And if you're killed, we've tried in my 17 years here, we've tried 5 or 6 jury trials. Every one of them received 20 years max. Every one of them, the jury did that. So I have a sense of what the people in the community think of this. We know people drink. We know they would drive. But if you kill somebody or seriously injure, the 12 jurors who sit over there have no sympathy except for the victim. 20 years maxed every time. We haven't had a jury verdict less than the maximum. That's how serious it's thought of universally. Well, you got 250,000 people who are frowning on your behavior. So you got to fix it, or you'll be held accountable. Now, doesn't say anything about what happened to the other driver. What do we know? What do we know?
As far as the driver of the vehicle we ran.
Were they injured?
Yes, Your Honor, and they settled out. I know she had
couldn't care less.
I believe she had
about
some
that. That's
pre-existing back injuries, and it exacerbated that when they were ran into the back of the vehicle.
what ran into the back of the vehicle.
Yes, Your Honor.
All right. As a condition of probation, you must serve 15 days in the county jail, and those will be on successive weekends. You go into the jail on or before 6:00 p.m. They release you at 6:00 p.m. on Sunday, and you get 2 days credit. And when are you able to begin that?
January 26th, it's Friday next week.
Friday week. You must report on or before 6:00 p.m. in the Jefferson County Jail Friday, January 26th, and each Friday thereafter at that time until you have been credited with 15 days service in the county jail. You understand, sir?
Yes, sir.
Anything else?
No.
That is all. Thank you. Please see the probation officer.
The court will call the Vincent Crime Matters case numbers 23-0005 as well as 23-00477.
Richmond Deputy Borough People.
Assistant Public Defender Sandra White on behalf of Vincent Klein.
Please state your name, sir.
Vincent Klein.
So am I understand, Mr. Clark? Matter has been adjourned again?
Yes, he's going to be, hold on. Your Honor, I'm sorry. He's getting a new level of care assessment to go right into inpatient. Now, they're not going to be releasing him into any type of outpatient. Something has changed. So now you're doing a new assessment for him to get put into inpatient. And his next court date is January 25th in that matter.
Hey. Because we're waiting on his sentencing, Your Honor, I don't know if it's necessary for us to adjourn for that purpose. And that's only because our sentencing agreement in Mr. Klein's cases was compliance with his circuit court probation. So we may be able to proceed today, since I don't know that the outcome of the assessment or his treatment will really affect anything unless he were to be non-compliant, of course. But
What's his bond in that other case?
Hold on, I have it. In his felony cases, it looks like it says no bond has been set.
Do you have a report?
No, I do not.
What are you saying?
I'm sorry, Your Honor, it got cut off by the interference. Could you say that one more time, please?
What is it you're saying you want to do today?
Well, no, I was just saying that because our sentencing agreement for Mr. Klein's cases was compliance with his circuit court probation, essentially, and he's been sentenced into felony drug court apparently, and I can tell that
Yes, not.
I'm sorry.
He has not.
He has not yet been sentenced.
Correct.
Okay. It's hard to hear because of the background noise in the jail. I saw that his cases have been removed from the public view on Odyssey, which was why I felt like, or why I thought it may have happened already, because they usually don't take them off and put them in that non-public status until that happens. So
Information I have received is that he has not been sentenced in yet.
oh, that's fine. I don't have a preference. I just wondered if it was necessary to adjourn, if we were able to do anything more today. But if not, that's fine too.
Can I say something?
Yes, Mr. Klein.
I had my my what you call it, assessment or interview with the public or the PSI to do my PSI report, probation people. And so she said she was on vacation and she couldn't find me and stuff. So she just did my report, and then I won't get sentenced to drug court until our next court date with Judge Cookie. But I don't want to keep adjourning this one though. She wants me to do presidential, she said again. So that's what I'm waiting on.
Your Honor,
I have to have the judge put in my paperwork that I can go, or I can't go and be able to do it.
Your Honor, I see what changed. If we could approach really quick so I could update the court and his wife.
I was gonna say, let's approach, because I got some information from his felony attorney too.
State of Michigan versus Antonia Burton, 14 FB 1443.
McDuffie for the people.
All right, in this matter, the defendant's supposed to be before the court today for a show cause, but has failed to appear.
That is correct. I don't have, let's see, she was discharged without improvement in July 2019 with a bench warrant for outstanding monies owed. And that's all I got.
Yeah, so this is for money. The court, defendant failed to appear, show cause, for failure to pay, and failure to appear. Will be scheduled for March 5th, 2024 at 10.
Your Honor, did we put the new date for Vincent Klein on the record?
At least I thought I did.
No, I don't think so.
30th is what I had said. Was I muted at the time?
We came out of the breakout room kind of weird, and you might have been muted because. So yeah, I thought you were just going to recall it in a minute.
I did recall it and say, I guess.
Oh yeah, we did hear you then.
What I said was in the Vincent Klein matter is that I feel comfortable sentencing Mr. Klein because he currently has been abusing his medication in the jail. In addition to that, he is not on sentence yet, and I don't know whether he's going to get sentenced into recovery court based on the. I don't want to hear anything from you, sir.
I'm not refusing. They took my
Did I
meds.
just say I didn't want to hear anything from you?
I'm not refusing my meds. They took them. I don't have my meds. I can't even get them. They took my meds.
And that his behavior in front of Judge Kunke was very troubling and has been noted in the JIS system. And as such, he may not be sentenced to recovery court. And I need to know that he's sentenced in that court before I can order that he comply with the probation sentence that he doesn't have yet. Mr. Klein, you can't be held in contempt of court for just getting up and walking out of court when I'm talking to you, which would be additional time.
So we called cause number 23-41401, the state of Texas versus Johnny Howard, and you were the second.
Yes.
And you were charged with the state jail felony of injury to a child. And go ahead.
Yes, Your Honor. I'm filling in for Mr. Bruce Smith today, and he previously had filed a record Defendant's motion to modify bond restrictions, asking for the ankle monitor to be removed at this time due to the defendant not having any issues up until this point, and it being a financial hardship on the defendant while he's looking for work, Your Honor.
GPS device is for, you're talking about a GPS device.
Yes.
There's a reason for that in cases like this. This is injury to a child. It's alleged he punched out the 6-year-old. So the GPS device is to ensure that he's not around children.
I understand that, Jerry.
And if something bad happens, we'll know who was there. And there was no victim contact. I mean, that's why the GPS is just, it didn't come out of the sky. It's because if you're going to punch out a 6-year-old, according to this probable cause affidavit and the grand jury indictment, you're looking at me or him, or are you paying attention, or is this boring you?
No, I'm listening.
All right. Here's the grand jury who's accusing you, not me. Here's the grand jury. They thought that there was an investigation, and family services was involved. The child made outcry to someone, then was at Garth House. Police investigated, and the way America is, in the way we look at taking care of children when children are at risk and are harmed. This is a state jail felony, which carries with it up to 2 years in the state jail. It is a felony. We treat it seriously. That's what the GPS is all about. Is if he's going to do this to a child, children are at risk until we can ferret out what happened here and determine whether he's unsafe for others.
I understand.
That's why it's there. Yeah, that's why it's there.
And Judge,
We're sensitive about children, and people who aren't, I don't even understand them. And the people who put me in this office want elderly people and children and those who aren't able to defend themselves from a 42-year-old man are going to be in a safe harbor.
Sure.
What's next?
Request a 30-day reset, Your Honor.
It is granted.
Thank you.
And for announcement. Thank you.
Thank you.
You don't have any contact with that child, do you?
No, sir. He has not.
Get a reset.
We'll give you a reset. Thank you, Judge.
Yes, sir. You're excused. Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am, can you hear it?
No, I know.
Okay.
I have no patience for that. But trust me, out of the day, I'm sitting up here, I'm the one that sees the drink.